Good afternoon, everyone. Thank you so much for being here. My name is Kelly Beard, Content Specialist for Maryland Realtors, and I want to welcome you all to our webinar, Intro to Commercial Leasing. Today, we have our moderator and legal associate, Diamond Smith, along with our guest speaker, Keith Hinder from Womble, Bond & Dickinson. Together, they will dive into our topic of today and the basics of starting to expand into the commercial real estate industry. This webinar will be recorded and sent out to all registrants after the conclusion. We do encourage your questions and we look forward to answering them. Please post all questions in the Q&A box below at the bottom of your Zoom screen. They will be answered at the end of the presentation. And with that, I will turn it over to Diamond.
Thank you so much, Kelly. As Kelly mentioned, I'm in-house counsel for Maryland Realtors and also the staff executive for the commercial section here. On behalf of the Commercial Alliance Committee, as well as the webinar subcommittee, we'd like to welcome Keith Hinder Jr. with Womble, Bond & Dickinson. So Keith represents clients in commercial real estate transactions, including the purchase, sale, financing, development, and leasing of all types of commercial properties. In addition to his transactional expertise as a commercial real estate practitioner, Keith is an experienced litigator. He has represented clients in matters involving real estate litigation, tax appeals, general commercial litigation, construction litigation, and insurance coverage matters in Maryland. This extensive litigation experience gives him a unique perspective, enabling him to develop legal strategies with his clients to avoid litigation whenever possible. Before private practice, Keith served in several in-house counsel positions, including claims litigation counsel at Geico Insurance Company. He also started his legal career as a law clerk to former Judge Thomas E. Marshall of the Maryland Third Circuit Court in Hartford County. Please bring a warm welcome to Keith. I'll leave it to you.
Thank you, Diamond. I really appreciate the introduction. Good afternoon, everyone. I am exceptionally pleased to have the opportunity to present this afternoon and give you an introduction about commercial leasing. The goal here is to provide some insight based upon my experience as a commercial real estate practitioner and to assist you in your capacity as a Maryland Realtor. Your success as a Realtor is predicated on your relationships and your reputation in the community, as well as your market knowledge. Although your experience and expertise is dedicated in this residential space, you may have clients that come to you to solicit your feedback and input on commercial leasing. Whether it's a client that owns their own commercial property or it's a prospective tenant looking for commercial property for the expansion of their business or to start the business. My experience as a commercial real estate attorney is predominantly, especially on the leasing front, tenant representative, tenant oriented. So my focus today is primarily through the lens of a tenant, but the concepts that we'll discuss are equally applicable to landlords and tenants. To give you a little roadmap of my presentation, I'll discuss the life cycle of a typical lease review. It starts with broker engagement, then we go to letter of intent negotiations, followed by lease review and negotiation, and then finally lease administration. So firstly, I'll start off with the broker engagement. Brokers are very similarly situated to you as a Maryland Realtor. Again, you guys have great relationships and great reputations in the community and have exceptional market knowledge. In the commercial space, the brokers are very important in driving the deal. And we want to make sure that we develop trust and have solid relationships with the brokers. And in turn, they have good relationships with the leading landlords and developers in the metro area. So to the extent that there's overlap with commercial brokers based upon your representation of clients in the residential space, I would suggest and recommend that you continue to foster those relationships and build upon the rapport that you've established thus far. If you have clients in the residential space that come to you, again, they're looking for commercial space or they're looking to lease commercial space. A commercial real estate broker is critical, and developing that rapport, again, is paramount. Some of the household brokerage firms, especially here in Baltimore, are CBRE, JLL, Cushman & Wakefield, and McKinsey. I work with brokers associated with these brokerage houses on almost a daily basis. And there's a number of great guys and ladies who I work with, and I'm fortunate to have these relationships. And in many instances, they feed me a lot of work. For instance, if they have an industrial user that's looking for space, but they don't have in-house counsel or specific real estate counsel, a broker will reach out to me and say, look, can you help my client out in negotiating the lease to make sure that they're protected? And at that stage, I usually have a letter of intent and then a form lease that is presented by a landlord. But again, the brokers are critical for my business development, and I'm fortunate to have those relationships. And I'd suggest that you continue to build your rapport and relationships with those brokers in the commercial space. They do essentially what you guys do, just in the commercial capacity. Brokers, they drive the bus on the deal terms associated with the commercial deal, from the rental rate to the critical business terms, where you're considering the commencement date, rent commencement, if there's going to be any sort of rent abatement, the overall lease term, operating expenses, to the extent there's any escalations for the base rent, those will be negotiated by the broker. The security deposits, renewals, right of first refusals, those critical business terms will be driven by a broker. Overall, especially in the office space, it's really a tenant market right now. In Baltimore City and Washington, D.C., vacancy rate is approximately 20%. So with these credit conditions, financing new and existing office buildings from a lender perspective and a landlord perspective is particularly challenging. Landlords are willing to make a deal and to sweeten a deal to avoid handing back the keys to a bank. They want to fill up their commercial office spaces as much as possible. So they're looking for tenants to lock in to longer term rates. And there are a number of favorable conditions out there for a tenant to take advantage of. So naturally, as a realtor, in your corresponding relationships with commercial brokers, you want to be very sensitive to timing. And broker involvement sooner rather than later is the key. It's much like, having the first group on a home where you know the neighborhood, you know if an opportunity is going to be presented for a prospective purchaser or for an owner who's trying to sell their property and looking at another house in that community or somewhere else in Maryland. Sensitivity to timing is critical. Although a tenant wants to avoid a time crunch, if the landlord, ultimately the tenant, they want to avoid a time crunch as much as possible. And if the landlord knows that a tenant is in a bind, they'll try and leverage and take advantage of the situation where they're looking for space. It's at the 11th hour. They need the space to operate. So broker involvement, realtor involvement, hand-holding with the client sooner rather than later to anticipate and prognosticate what the needs of the client will be sooner rather than later is rule number one. If you have more time, ultimately you're going to have more options. So I will now pivot from the broker relationships to letter of intent negotiations and provide a little bit more detail about some of the expertise that I can bring to the table as a real estate practitioner and as a lawyer for a tenant. The LOI is broker driven, but I like to say it's nice to have an attorney chaperone associated with a letter of intent. It provides the framework for the transaction, and it also sets the expectations for the parties. And from a pure business standpoint, I defer to a broker based upon their market knowledge, negotiation ability, and relationships within the industry. That's why a broker's on board. That's why you're hired, because of your relationships and market expertise. Where there are nuances to the transaction, that's an opportunity for an attorney to provide feedback and tighten up the drafting, especially if it's a vanilla variety letter of intent that we've discussed previously. A critical area where I can provide feedback is if there's a build out or construction component to a tenant space. Pivoting off our discussion about the market, in today's market, office tenants are receiving all kinds of concessions from landlords. And one of the most significant concessions and incentives deals with the tenant allowance, which is a payment or a capital expenditure by a landlord for a tenant's build out of the space, whether it be office, whether it be industrial or retail. If the tenant receives a significant allowance, which is money that's handed over by the landlord to the tenant to facilitate the construction of their build out for their home operations of the space within the office building, it's important as tenant rep counsel to line up architects on design work, line up contractors to do the work, and to customize the design space for the tenant. During letter of intent negotiations, when a tenant allowance, especially significant tenant allowance is in play, I like to include any items or specifications that are absolutely critical. That way, guys, there's no daylight between what is absolutely important for my clients and the business terms that are negotiated by the parties. And I'm not in a position where if we get to lease execution or lease negotiation, I'm trying to build critical items that otherwise should have been agreed upon at the outset. Now, generally, for tenant allowances, landlords, they're willing to pay hard costs, but see if they'll also pay for soft costs, which would include architect, engineer, and space planning fees. The construction work, if a landlord is controlling the build out for a tenant, make sure from a tenant's perspective that the project is competitively bid and reserve the right to approve contractors and plans. That the tenant wants to be a team member with the landlord as the build out plays out. We want to be a part of the process and the approval, to have a good rapport with the contractor, to make sure that the quality of the finishes and the construction that's being done, the tenant's satisfied with it, the landlord also signs off on what's being done. So having the tenant involved for every step of the process, which can be specifically memorialized in 11-10, is important. So at this stage, it's important, especially as tenants counsel, to inquire about construction management fees. And you want to try and negotiate these down. Typically, a landlord, they'll say, look, I'll do the tenant build out and I'll pay X amount per square foot. But if I do it, I'm going to charge a construction management fee because I am hiring the contractors, I'm hiring the architects, I'm hiring the parties involved for the ultimate build out of the space. Generally, that's fine. But to the extent there is a management fee, you don't want it to be too high. You know, anything beyond 5% is above market. I try and negotiate that down as much as possible. Ideally, you want it eliminated, but usually, you know, we land on 2 to 3% for construction management fee, which ultimately is paid back to the landlord. What I also like to do in the letter of intent stage, and it deals with the tenant allowance and the tenant build out, is reserve an early move-in right. This is generally granted to tenants, but again, it's important to have this clarified in the letter of intent to the extent you can do it. Typically, a landlord will give a tenant 2 to 4 weeks of an early move-in right to install fixtures, equipment, and finishes associated with the landlord space. It's really nice as a tenant to get in there as soon as possible before you pay rent and make sure everything, to the extent possible, can be up and running, from cabling to fixtures and equipment. You want to be up and running as soon as possible as the tenant, and you want a specific covenant in place, which can be ideally addressed in a letter of intent that makes it clear, hey, tenant, yes, you're allowed to come in a couple weeks, at least in advance, to install what you need to operate your business. Now, importantly, in almost every circumstance, the letter of intent that we're discussing, it's non-binding, okay? It's a talking point. It's in writing and it's ultimately signed by the parties, but it's non-binding. And this non-binding sort of Miranda warning it should be conspicuous in the document. And it allows me, as a lawyer, to come in and demonstrate my value. To buttress off what we were just talking about tenant improvements, to make sure that we have rights to collaborate with the landlord, choose a contractor, negotiate down a construction management fee, this letter of intent, it's non-binding, but it still, sets the expectations. And despite the LOI being non-binding, as outside counsel, the last thing I want to do, the absolute last thing I want to do as a deal lawyer is to try and rewrite critical terms that are already agreed upon once the letter of intent is signed. So it's not incumbent upon me, and it's not something I ever want to do. If there's a signed letter of intent, guys, if it's signed, it's not within my province as a lawyer to come back and say, no, I don't think that those business terms are appropriate. What I can do is have the ear of the tenant or the landlord, depending upon who I represent, and make sure that the critical issues in the lease are addressed before the letter of intent is signed. But once it's signed, although it's non-binding, we're going to go off the template that's established by the parties signing off on an LOI. So now I will pivot from the broker to the letter of intent, and finally to, or at this juncture, to lease review and negotiation. And this is where I really demonstrate the value. I have the lease, I have the letter of intent. This is where all the legalese is incorporated into the document, into the lease itself. And at the outset, what I like to do, especially in a tenant capacity, is try and temper expectations, okay? Unless my client, as the tenant, is taking over 30, 40% of an office building or retail space, the landlord usually has the advantage and the leverage. To a tenant, the lease premises, it gives us a place, it gives my client a place to make money. Whereas to the landlord, it literally is the money generator as a landlord in that capacity. The rents that come through and are ultimately paid to the landlord are either pocketed or they're paid to the lender to pay down the loan and meet their loan covenants. But that is the asset, the building itself, and the money that's generated through rents. So the landlord, again, is in the business of leasing space, and the building is its major asset. Therefore, the landlord is hyper motivated to plan for the long term and present tenants with conservative leases to maximize the returns. Some lease terms to pay close attention to, especially as tenants counsel, are the rent commencement date and the overall commencement date. The rent commencement date, it's a foundational but very critical provision, and there are two varieties. The first is a fixed date concept, where there's a certain date, or there's a certain number of days after lease execution, which is typically called the effective date of the lease. And under this structure, it's usually when the tenant is in control and in charge of its own construction. The landlord, they want to set a specific date, again, to set expectations, to have it set in stone as to when they'll receive the revenues from the tenant being in place and ultimately paying the rent. They want this accelerated as soon as possible. Now, as tenants counsel, it's important to have substantial completion keyed to the tenant improvements being completed. On deals where the landlord, they're doing the build out, I like to, as tenants counsel, insert an estimated completion date and negotiate a right to liquidated damages in the event that the tenant improvements, they're not performed or they're not done by a specified date. This incentivizes the landlord to timely complete the build out and protects the tenant from paying double rent if it's leasing space in another location. There are many instances where I'm representing a tenant. They're somewhat satisfied in existing space, but they're looking for something better. Usually they're looking for more space or a better location. Much like your clients in the residential form. They're looking at a bigger house for an expanding family in a better neighborhood. What they have is fine, but it's not good enough, and they're looking for the next objective for their family circumstance. So if that's the case, the worst thing that can happen is tenants in a bind where they're paying rent on their prior space and the space that they're really excited to move into isn't completed yet. And because the rent commencement date was not negotiated appropriately, they're in a bind where they're paying double rent, like you could be paying a double mortgage. Again, that is worst case scenario, but as counsel, it's incumbent upon me to make sure that a tenant is protected and that the rent commencement date does not come down until there's substantial completion of the tenant build out to avoid the tenant paying double rent. And it, again, incentivizes the landlord to complete the work as quickly as possible. What I also like to do is have a landlord covenant in place regarding the quality and workmanship of the work. It's very simple, in a good and workmanlike manner. I just want to keep the landlord a little honest there with respect to what they're doing. To the extent that there's problems and there's an issue after completion regarding the quality of the work, we can point back to the lease and say, landlord, you'd agreed to perform this work in a good and workmanlike manner. To the extent it's not, it's a default on you, the landlord. I also like to put in language in accordance with approved work drawings and in compliance with all laws, which, pivoting back to the letter of intent discussions we were having, that's something that should be in the LOI and should be a covenant that permits the tenant to be a part of the process with the landlord throughout the entirety of the build out process. Another important provision that I key in on as tenants counsel is the assignment and subletting provision. Especially with a long-term lease, you want to preserve your companies as a tenant's right to assign or sublet the premises and have that nimble flexibility in the event that, you know, market conditions make the sustainability of the business compromised. In nearly every commercial lease, a tenant is prohibited from assigning its interest or subletting the space to another entity without landlord's consent. This status quo, it's understandable because the landlord, they have a vested interest in the tenant's presence in the building, and they evaluated the tenant. During letter of intent negotiations, before they sign that up and they move forward with the lease, they've had an opportunity to take a look at the tenant's track record and their business acumen and ask for financials, which keys into what the security deposit will be in negotiating the letter of intent. If you have a very credit-worthy, successful business, you know, there's not going to be a personal guarantee usually in place, and that security deposit will be perhaps 1 or 2 months rent. As a tenant, when you represent a tenant like that, you know, you have the leverage because you can look at a number of other spots in Baltimore City and say, look, I'm bringing together an established tenant that's going to pay its rent on time. It's going to be a nice, attractive feature to your office building. So going back to our discussion about assignment and subletting, at the very least, you want, as a tenant, the right to assign. It can be subject to the landlord's consent. Again, that's fine as well, and that's certainly market. But at the very least, you want the landlord's consent not to be unreasonably withheld, conditioned, or delayed. And typically, landlords will agree to that. If there's an assignment opportunity for another business that does something similar to your clients, and they're able to come into the space, and your client's able to exit and pivot to something else, you know, you want to afford your client that sort of flexibility if it's just not working out at that particular space. And having that assignment right, where yes, it's subject to the landlord's consent, but the landlord's consent cannot be unreasonably withheld, conditioned, or delayed. That's a fine compromise that I usually shoot for as tenants counsel. Another absolutely critical provision that requires a lot of attention involves operating expenses. In a commercial lease, the operating expense clause lets the landlord recover normal out-of-pocket expenses associated with running a building. That's all it should cover. From a tenant's perspective, operating expenses should be tied directly to benefits that a tenant gains in accordance with the lease and associated with the tenant's use of the building. In a multi-tenant building, a tenant's bill for operating expenses is based on the tenant's overall footprint in the building. It's known as a proportionate share. So, if 100,000 square foot building, my client has 10,000 square feet, their proportionate share is 10%, and they're going to pay 10% of the overall operating cost for the entire building. And again, generally operating costs, they should be limited to those reasonably necessary and appropriate expenses for operating, maintaining, and managing the property. That's it. This is not, especially from a landlord's perspective, excuse me, a tenant's perspective, this is not a profit center. In addition to the base rent landlord, you can't use operating expenses to pass those to the tenant to make money. There could be a management fee. You see that in a number of leases. I try and negotiate that out to the extent I can, or have that mitigated or minimized as much as possible. But at the end of the day, the operating expenses that are passed on to a tenant should not lead to a windfall or a profit center for the landlord. And to do this, I include specific covenants that the landlord shall not profit from a collection of operating expenses. And it's difficult for a landlord to argue with that. The profit, to the extent there is any, it's based on the base rent. It shouldn't be based upon expenses that are passed on to the tenant. I also like to include a catch-all exclusion that operating expenses shall not include any expenses under generally accepted accounting principles that would normally be passed through as an operating expense by the landlord of a similar building. So if other landlords in the Baltimore metropolitan area that have very sharp tenants that have looked at these leases, if they're not paying operating expenses, nor should my in the general area where I'm negotiating the lease, the pass-through should be consistent. They should just be based upon the.
I can't, just one comment. Someone said that when you look down, they're unable to hear you.
Okay, thank you. So to drill down a little bit further, certain items that should be specifically excluded. Any services furnished specifically to other tenants, those should be excluded. Leasing commissions and advertising costs, landlords' financing fees and charges, and capital repairs and replacements to the building. These are big ticket expenses that should be excluded from the definition of operating costs. Now, with respect to capital repairs and improvements, they tend to benefit the landlord in its ownership of the building through increases in rent or a greater sale price. But for tenants, there's only a marginal benefit, and it's applicable to a tenant's term during their tenancy. And if capital improvements cannot be completely negotiated out of operating expenses, then at the very least, the item should be amortized over the expected life of the asset during the term of the lease. So the pass-through, guys, it's only applicable to the tenant during the term. As tenants counsel, my client shouldn't be responsible for capital expenses that exceed the useful life during the term when my client is actually in the building and operating its business. It's also important, as tenants counsel, to reserve a right to audit books and records. This, guys, at the very least, it keeps the landlord honest, okay? It's a reasonable request, and if it's not already stipulated in a lease, it makes it incumbent upon the landlord to turn over a detailed statement of operating expenses at the end of each calendar year. It's usually within 4 months. So by April, it's incumbent upon the landlord to send my client, the tenant, a bill as to what the operating expenses were for 2023. And I'll encourage my clients on the tenant side to follow up with the landlord to make sure that they have a proper accounting. And I want to reserve a right to audit that statement and the landlord's books and records. So to the extent that there's any overpayment, that eventually is credited back to your company, and there's a covenant in place that I negotiate into a lease that makes it a landlord requirement to do so after my client conducts an audit, and in the event it leads to a determination that there's any overpayment. And again, from a general concept standpoint, it keeps the landlord honest with respect to their accounting and what they're attempting to pass on to a tenant. Another absolutely critical item that I'd like to have incorporated into a commercial lease is the notice and cure right. As counsel, notice and cure rights in a commercial lease, they're vital. And you must have these. Guys, it's absolutely critical to have these as a tenant because you want the tenant to be notified of a breach. And once there is a breach, it provides an opportunity for me to come in, to work with the tenant, and ultimately reach back out to the landlord to negotiate a resolution. If there's a failure to pay rent, there's a failure to pay rent. You know, in many cases, that can be due to an overlap in accounting or someone in accounting not being in a software mishap. But as long as we receive notice that, hey, we missed a rent payment and we're trying to remedy that as soon as possible, that avoids a situation where there's a disconnect between the landlord and the tenant that would ultimately lead to the landlord exercising very harsh punitive penalties that are traditionally built into a commercial lease. Yeah, and again, these damages and remedies, they're punitive and can cripple, absolutely cripple business operations. In addition to seeking an eviction, a landlord can outright terminate or accelerate the rent for the balance of the term of many commercial leases. So as counsel, it's important for me to be notified, to work with my client, and to reach out to the landlord to work on a resolution with respect to any alleged breach of the lease. To drill down a little bit more on this concept with respect to notice and cure rights, I try and stretch the cure period as much as possible. So to the extent that there's a missed rent payment, my client has 5 business days to remedy that after notice. They pay the rent payment. Again, usually that's not attributable to the tenant's unwillingness to pay. You know, there's a glitch in accounting. There's new personnel in place, and for whatever reason, it wasn't accounted for with respect to the rent payment, and we're able to deal with that situation. With respect to non-monetary defaults, I like for there to be at least 20 days where my client's apprised of any non-monetary default associated with it. I'll also point out a handful of other lease provisions that require recalibration, usually with respect to tenant rep on a commercial lease. Access. Typically, a landlord will request that they have access to your premises under any circumstances. You know, whether it's to make repairs or for the general overall operation of the building, they want to have an access right. I try and limit that as much as possible. It's reasonable for the landlord to have access for the operation of the building and in case there's any emergency in the premises. But it should be incumbent upon the landlord to provide written notice or email notice to my client, letting my client know, hey, we're coming in to replace X or repair Y. You know, my client should be apprised if the landlord seeks to exercise any rights to access the premises, so they're ready. You know, whether it's a client or a customer meeting or operations happening on a particular day, my client's able to pivot and make sure that their business is not adversely impacted based upon a landlord's exercise of their access right. Another provision that I'd like to address is the holdover provision. I resist an obligation for my clients as a tenant to restore the premises. If there are, to the extent that there's a build out done, we're not required as the tenant to deconstruct that building. We're required to remove our personal property and equipment. But other than that, we're going to leave it in broom clean condition, and it's not incumbent upon the tenant to restore or otherwise deconstruct the premises that was fashioned for our space. That eliminates some costs on the back end of a lease. I also key in on the permitted use provision of a lease. That we want to make sure, guys, as tenants counsel, that the use is broad enough. That what our client's trying to accomplish can be done and effectuated in the space And that should be very clear in the permitted use. Typically, landlords will say, you're only permitted to do X. I'll go to my client and say, is this permission, is this broad enough for your use? So what I'll do in many instances, if we think that the use may not be broad enough, I'll incorporate language that my client's business and uses incidental thereto are expressly permitted in those premises. In many cases, a landlord will require or insert a relocation right or a landlord right to take its security interest in personal property. I typically resist these rights and have them deleted outright. Finally, going through the life cycle of a lease, we address lease execution and administrative issues. Organizationally, it's important for a tenant to get to know building management and landlord representatives. You want to keep their contact information handy and readily accessible, and I encourage my clients as tenants to reach out as soon as the lease is executed to make those introductions. Because in many instances, we're going to lean on building management to repair and manage the premises and make sure it's in a first-class condition consistent with the lease. If there is any sort of landlord default where they need to be notified, it's also important as landlord's counsel for me to follow the notice procedures contained in the lease to the letter. Okay, I need to send written notice and make sure it's done via certified mail or overnight delivery. Make sure that I'm tracking the notice requirements in the lease to the letter. I also like to do a summary of important dates if necessary, and this keeps substantial completion date, rent commencement, early termination, and renewal dates on our radar. And I can reach out to my clients prophylactically and say, look, your renewal rate's coming up. What are your thoughts on maintaining your existence at this premises? Or if you're not really satisfied, hey, do we need to go out to the Maryland Realtor who put us in contact with the broker and see if we can find other space and look at other potential transactions in the metro area to serve your business. Renewal rights, guys, are critical. The lease will govern when the notice is required to timely exercise, but they're absolutely vital. It's important to negotiate these in, pivoting back to our letter of intent negotiations and discussions. And as counsel, I like the calendar of the state because at the end of the day, a renewal right, it provides a tenant with control of the space at the same location for at least a number of years. And in connection with exercising that right, we want to make sure that during that renewal period, the rent is market, it's consistent with the market, and there are appropriate concessions that would be in line with the tenant looking at other space in the metro. So that is a general overview of a lease review and negotiation process for broker engagement, letter of intent negotiations, lease review and negotiations, and lease administration. And I'm happy to take any questions in connection with the presentation. Thank you for your time.
Hi, Keith. We do have some questions. I'm going to ask them as they came in. It says that a few questions asked. Do you have a sample LOI or a checklist for a lease that you can show them?
Yeah, it's a little difficult for a one size fits all situation, and it's dependent upon whether it's office, industrial, retail, there's a multifamily component. I am happy to assist with those forms to the extent that there's negotiated terms in place and parties are a part of that negotiation, but it's difficult just to send out a form.
Okay, we'll circle back with that at the end of the presentation. And then also a question was, what does the letter of intent say? Does it also show proof of funds or balance sheets?
So a letter of intent will generally have a covenant that the tenant is, or not a covenant, but a request that the tenant provide their financials. That letter of intent for an industrial lease is very bare bones, where it's the lease rate, it shows if there's any escalator in place, the term, the conditions of the build out. For an office space, it's a little bit more robust and deals with the concepts associated with the tenant build out. But a balance sheet is not in the letter of intent. It's usually a request for the tenant to forward their financials to the landlord for their review with respect to a security deposit consideration. And the general business terms, which, you know, the most important are how much are you paying in rent? What are the operating costs or projected operating costs? And what's the term? So those will be built into an LOI. And again, that's more of a broker-driven process with, as I say, attorney chaperoning to the extent we can come in and provide some guidance and counsel.
There's a question on for residential agents. Is it necessary to have a commercial real estate license? I have in the past had a commercial lease that was successful. That may be a question for me, but did you?
I think that's a question for you, Don.
Okay, I did answer that, and I think I answered generally, but I said generally having a real estate license is the requirement to conduct a commercial transaction. However, there are certifications and classes that commercial realtors take that a residential agent may not have taken. And because of that, we encourage residential realtors to partner with a commercial real estate agent or send a referral to a commercial real estate agent. And also, as Keith mentioned, having an attorney by your side can also help you with that transaction. So there are sources there or resources there to help you through that transaction. Another question for you was, is there a difference between substantial completion and beneficial occupancy?
That's a good question. There is. There is a nuanced difference. You know, substantial completion means that the premises is ready for the tenant outside of punch list items traditionally. It's ready for the tenant to come in and use the space. Beneficial occupancy, you know, I like to have a key to actually when the tenant is operating the business. You know, when there's a certificate of occupancy in place and they have employees on the floor of the premises. I like the latter definition to be key to rent commencement date, beneficial occupancy as opposed to substantial completion. There is overlap there, but there's a bit of a nuanced difference between terms. Great question.
And another question is, what is the standard deposit amount for commercial sales?
For a sale?
Yes.
Standard
deposit.
I see it, you know, around 5% of the overall purchase price is traditional, 5 to 10%. Can even be a little less than 5%.
I've seen that as well. Are taxes included in operating expenses?
Yes, good question. Taxes are a pass-through in operating expenses. Taxes, insurance, utilities, janitorial, you know, operating costs for running the business, for running the building, those ultimately are operating expenses, and 9 times out of 10 will be passed through in some capacity.
Okay, and then some sources that a residential agent can access for commercial lease opportunities outside of Bright MLS. I believe that may be a question for me as well, or do you have resources that you can share?
Yeah, I have, there's a number of brokers that I work with for commercial space. So I think, you know, some introductions to those brokers. I'm happy to, you know, follow up with any questions individually based upon what product and asset type we're talking about, whether it's industrial, office, or retail, facilitate those introductions. But I think having a contact in the commercial space for brokerage would be tremendously helpful. And I'm happy to facilitate that introduction.
Also, just so everyone knows as well, with Maryland Realtors, with our commercial section, we actually have a commercial symposium that will be taking place March 28th. If you have not registered for that, that will be a great component for continuing education classes. It's a robust opportunity to expand your knowledge of resources that are available for commercial realtors. Also, we have partnered this year with CCIM. There's also SILR. Those are acronyms for membership opportunities, commercial investment opportunities. Keith mentioned industrial, retail. That's what SIOR is a makeup of. So those are other agencies that you can benefit from with taking classes, and Maryland Realtors is continuing to partner with those groups as well. So those are resources. Another question for you, Keith. We have a lot of questions. You guys have a lot of good questions. So explain in commercial lease transactions the pay structure to leasing agent. I heard that some of the pay happens way later in time.
Yeah, usually it's tiered upon lease execution and each lease year. I don't have that expertise, and I would defer to a broker as to how they're paid. But yeah, leasing commissions, that's typically a landlord expense, and it's tiered throughout the lease term.
Okay, and then another question that I think is a general one that we received. Is it advised that all lease transactions have attorneys involved? For example, even small office leases?
If it's a commercial lease, yes, it's my suggestion and recommendation to have counsel involved. And it could be, I don't want to say cursory, but a bare bones review to make sure that the business terms match up with the letter of intent. And I guess to take a step back, that's one of my primary objectives as legal counsel, to make sure that the legalese matches the business deal. Usually that's through a negotiated letter of intent. To build in notice and cure rights, to make sure that the operating costs are appropriately allocated and ultimately passed through to the tenant. So, my pitch would be, yes, it's always a prudent, good call to incorporate counsel in connection with any commercial lease. And although it may be an expense for your client at the outset, it can really pay dividends in the future. When that tenant signs on the dotted line and they agree to something with respect to operating expenses where they're paying through the nose year over year, they're bound by that obligation, and a landlord can enforce those contractual terms for a commercial lease. So it's prudent to have another set of eyes come in, take a look, provide some suggestions, and at the very least, guys, I think it gives clients some peace of mind in moving forward with the transaction as well, to have it blessed by the attorney.
Okay, and I think you answered this one, but ask if the landlord's building insurance is considered operating expenses.
Yes. Yes.
Okay. And then when talking about days, is notice in calendar days or business days?
Yeah, good question. I like to have it business days when I can for a tenant. Typically, it's calendar day, but especially for a monetary default, I'll start with 5 business days. Usually, it lands on 3 to 5 calendar days. Yeah, time is important for a tenant.
Mhm.
Of course, very important for a landlord, but I would say 70–80% of the time we're talking about calendar.
What's a reasonable amount of time to ask for landlord to give access to the tenant?
Another great question. I push for about a month, 30 days before the lease starts to have access with respect to your installation of FF&E, installing your fixtures, your equipment, what you need to operate within the premises. So usually a compromise is between 30 days, 15 calendar.
Another question is, when it's time to renew the lease, does it go every month or? Okay, when it's time to renew the lease, is it month to month? Or are you obligated to sign a lease for the same term?
Good question. So the letter of intent, to the extent that there's renewal rate or renewal right, it should be in the LOI and then built in to the lease itself. Usually, guys, it's 9 months, 12 months before the expiration of the first original term, where the landlord is incumbent upon the tenant to reach out to the landlord and say, hey, I want to exercise my renewal. And then the renewal rate, in many instances, it's not set at the time of LOI or even in the lease. What they do is they'll say, look, we'll give you a renewal right. So you're in the space for 5–7 years, which is standard for an industrial space. That's your original term. If you want to exercise renewal, we'll give you an additional 5 years, and you have to let us know at least a year in advance of the original term's expiration. And if you do, what we'll do is we'll give you market rate, and the landlord will then send their proposal for market rate. There can be an objection by the tenant, and the way it's traditionally resolved in a lease negotiation is that it's baseball arbitration, where the landlord sends one number. If the tenant's not pleased with that and thinks it's not appropriate with the market, they'll send their own, and then both brokers choose another broker, a third-party disinterested broker, who makes a determination as to whether the landlord's number or the tenant's number is closer. And I really like this because it drives a reasonable compromise from the landlord and from the tenant, where the landlord, if there's baseball arbitration in place, they're not going to be inclined to provide a rate that's pie in the sky, that's really high. Because if they do, and the tenant comes back with a reasonable rental amount, and ultimately a third-party broker is making that determination, the tenant's number is going to carry the day. So it drives the clients and the brokers to a compromise with respect to market rate for the renewal.
If the tenant is exercising their option to renew, can the landlord deny that if all payments and things have been met per lease? What are the tenant's rights?
There's usually a prerequisite to exercising renewal, and it's that the tenant is not then in default or hasn't been in default for more than 2 times during the lease term. So yeah, there are preconditions to a tenant exercising the goodies, as I like to call them, with an important one being the renewal. So if you are a tenant that's not paying your rent on time, and that is documented through notices of default throughout the lease term, typically in a commercial lease, there will be a prohibition for you as the tenant to exercise your renewal if you breach the lease X number of times.
When is it appropriate to introduce a client to the attorney? Is it at the time of writing the LOI or before?
LOI is a good call when you're around letter of intent, final negotiations, that I defer to the broker, I defer to you, realtor, with your market knowledge, and your client relationships. But once you guys are close on the rent, on the term, I can come in and usually make sure that you're protected, or that there's business terms that are very important to the tenant that are somehow memorialized in the LOI. So towards the tail end of letter of intent negotiations, it's probably a good middle ground. Now, ideally, I'd like to be involved from the very outset, but in many cases, I'm not providing that much value. Again, the broker is driving that based upon the market, but it's never a bad idea for me just to be apprised. I'm not billing time. I'm not spending a lot of time dedicated to the initial draft of the LOI, but I'm here part of the process, able to answer questions along the way as well.
Should the tenant be able to share in the savings of reduced operating expenses or expenses when they decrease? For instance, the market goes south and the property taxes are greatly reduced.
Yes. Yeah, going back to that audit right, to the extent there's a reassessment for the property and the landlord's paying less in taxes, then the tenant should correspondingly be entitled to that reduction. Now, if the landlord is driving the process to have a reassessment, it has to hire a lawyer and professionals to object to the current assessment, then the tenant should pay for that cost proportionate to their proportionate share, the 10% that I discussed earlier, if they have 10,000 square feet in a 100,000 square foot building. But ultimately, they should share in those savings as well. Again, the pass-through should only be attributable to taxes, operations, maintenance, and repairs associated with the building itself. It shouldn't be a windfall for a landlord. And for a landlord to have a contract position, it's not market, and would be inappropriate.
So also they wanted to stress that in our code of ethics under Article 11, this is for residential realtors who are seeking to get into commercial, that it's required that agents have expertise in the area that they're practicing in. So that's why we encourage to have an attorney if this is an entry into the commercial leasing world. To have an attorney there with you, or to have an experienced commercial realtor, as I mentioned earlier, can do wonders as far as how far you can go with your knowledge in that area and on that particular property. A waiver of subrogation. I think the question is, what is a waiver of subrogation?
Yeah, waiver of subrogation, it's standard to have it in there to the extent that there's negligence associated with either tenant's operation of its space or the landlord's operation of the building, insurance should cover that. And the parties shouldn't look to one another to recoup any amounts that are associated with a loss associated with it. What a waiver of subrogation does is it pushes the insurer to pay for any losses that are attributable to someone's negligence. The landlord is going to be responsible to insure the property as well as the tenant. And again, to the extent that there's a loss that's predicated on negligence, the insurer should cover that cost. The party shouldn't fight over it.
There's one question that's a general one for residential agents. I think it says, can you provide the location on the website to the requirements for getting into commercial real estate? Also, are there separate commercial brokerages for commercial transactions? If so, agents that do both residential and commercial will belong to two different brokerages. So I'm going to answer that one. So there are resources available on NAR's website as well that are listing out the requirements, continuing education requirements. There's also, if you contact myself, Diamond Smith at Maryland Realtors, you'll see me there, and you can inquire as to which classes are being offered. So our Commercial Alliance is always promoting the classes that are happening. CCIM allows has a plethora of class material for commercial realtors, and also certifications that you may be seeking, SIOR as well. So those are places that you may be able to go. To break down your question as to if you have to switch agencies, it depends on your brokerage. Some brokerages offer both residential and commercial. Some are exclusively commercial, and then some are exclusively residential. And it's up to you to have that conversation with your broker to determine whether or not you're able to join both a commercial brokerage and a residential brokerage, or if there's exclusivity that's involved with being a residential agent at your brokerage. So you can inquire, that question is for your broker, essentially, and you can see what your options are from there. Another question is, I had a situation where a landlord wanted the deposit, but when I asked for the entire lease for my review, they refused. What is the law in Maryland on a commercial lease?
I would not pay a deposit unless I have that. So I think that's more of a business termination. The deposit, firstly, should be tied to lease execution. And I guess foundationally, yeah, I'm not putting up any money unless I have the lease in hand and it's fully negotiated. As a tenant, why should I put up money with something that I haven't agreed to? The lease sets the expectations for the parties and the covenants for the landlord and tenant. So I think that request from the landlord in that particular instance is not consistent with the market, and as tenants counsel, Jeff, make any payment. Definitely.
That you trailed off on that last part, Keith.
I would not recommend that a tenant make any sort of payment to a landlord unless the lease is executed.
Okay, and then the final question I think we have time for is a cert of OCC required for each new tenant in a space, even if there is no major build out?
As the tenant, I want to make sure that I have a certificate of occupancy and I'm able to move forward. So going back to the substantial completion definition, as tenants counsel, I'll try and have that covenant in place that substantial completion is also tied to a certificate of occupancy. Again, it's critical that I have the permits and the certificate in place to move forward. Typically, that it's incumbent upon the tenant to apply, perhaps along with the landlord, for the certificate of occupancy, but the premises should be in a shape based upon the landlord's build out where I can obtain the certificate of occupancy.
Okay, and then we're at 1:59. We have more questions, but with these questions, you all, I do encourage you to send them over to the legal hotline, and then I can also prepare them and maybe be able to answer them through there or through through Keith as well. So my email address is diamond.smith@mdrealtor.org. And we also have a legal hotline that's available Monday, Wednesday, Friday with Maryland Realtors. So that's out there for you if you have more questions. If we weren't able to reach your questions today, we certainly can find the answers for you. Shoot them there. But thank you so much, Keith, for your time today. Our agents absolutely are I'm sure the knowledge is out there. So hopefully we were great resources for everyone. But thank you for your time.
Thank you for the opportunity to present. Nice to meet everyone. Format, and I'm happy to follow up with any specific questions. Feel free to give me a call.
Thank you, everyone. We will provide, Keith, you'll be attached to our email that goes out to all attendees with the copy of this recorded webinar. So you guys will have this for your use. You can look out for that email typically tomorrow around noon. And Diamond and Keith will be CC'd on that so that you have that information. If you have any further questions, like Diamond said, please reach out to our hotline. And the commercial symposium that she mentioned, we will also include that in the email. If you guys are looking to further your education, we will get that over to you as well within that email too. All right, take care.
Thank you.
Thanks, everyone.
Bye-bye.